हेलो फ्रेंड्स, हाउ आर यू। आज हम इस वीडियो में इंडस्ट्रियल डिस्प्यूट एक्ट 1947 में देयर इज वन चैप्टर ऑन नोटिस ऑफ चेंज व्हिच कंटेन्स बेसिकली टू sections, section 9A and section 9B. We will be discussing the provisions of this chapter in this video. So let me share my screen with you. Okay, so what exactly I am showing you here is the fourth schedule from the Industrial Dispute Act. Basically, this schedule is all about the list of conditions of service for which the employer needs to serve a notice to the workmen before bringing out any changes in these conditions of service. So notice of change is nothing but it is a information which needs to be given by the employer to the workmen who are likely to be affected by change in the conditions of service which is proposed by any employer. So this is the list of those conditions of service for which the employer is required to serve notice to the workmen. Like for example, compensatory and other allowances, wages or mode of payment of wages, leave with wages and holidays. So these are all are specified by way of fourth schedule under the Industrial Dispute Act 1947. So moving forward, so there are basically two sections, section 9A and section 9B, which are there under chapter 2A, that is notice of change. So what are the conditions which need to be satisfied by every employer before bringing out any proposed change in the conditions of service? That is 21 days of notice. That is 21 days of notice. So 21 days of notice need to be served by the employer before bringing any change in the conditions of service, as I have shown you in the fourth schedule of the Industrial Dispute Act. So these changes are mentioned in the fourth schedule, and what is the basic requirement which need to be satisfied by the employer? There should be a time gap of at least 21 days in between the date of the notice and date of the effective change in the conditions of service. So no employer can bring out any proposed change without serving this notice of 21 days to the workmen, right? Okay. And the nature of change has to be specified in the notice to the workmen who are likely to be affected by such change. Okay. And in prescribed manner, the notice has to be served by the employer to the workmen. Okay. Coming on to, this is basically section 9B. I'll discuss it. But before that, here one more thing is mentioned under section 9A, that notice rule is not applicable in certain conditions. So what are those conditions where notice rule is not applicable? It means the employer is not under mandate to serve 21 days notice to the workmen. What are those conditions? First of all, if any proposed change is basically given effect out of any settlement or award. So if any settlement is there in between the employer and the workman, and pursuant to that settlement, or if there is any award which is being given by any labor court or tribunal, then pursuant to that settlement or award, if any change is to be given effect, then that can be done without serving this 21 days notice, right? Because this award is given by the labor court or the industrial tribunal, or because both of them are mutually agreeing with respect to change in the condition of service. So that is why automatically there is no requirement of serving this 21 days notice. And secondly, where the workers are covered under these rules. So if workers are working with such organizations where different rules are applicable, for example, your fundamental and supplementary rules, or civil services classification control and appeal rules, like so on. So if these rules are applicable to the workmen, then also the requirement of serving 21 days of notice is not applicable at all, right? Because they are covered with different leave rules, right? So for them, the employer need not serve notice to his or her workers. Coming to section 9B, basically section 9B gives power of exemption to appropriate government, wherein if the appropriate government is of the opinion that the application of notice rule is prejudicial to the employers or it is causing serious repercussions on the employers, then in that case the appropriate government can exempt such employers with the serving of 21 days notice to workmen for giving effect to any change in the conditions of service. Okay, like for example, in case of national emergency or in case of natural disaster. So these rules are made flexible and the appropriate government can give exemption to employers in such cases from the notice rule. Okay. That's it from my side. Thank you so much. So अगर आप UGC नेट कोड 55, कोड 17 या कोड 08 के लिए तैयारी कर रहे हैं, then you can get in touch with Human Peritus, which is having vast past experience of almost 14 to 15 years in teaching these subjects. With Human Peritus, you will not only get the live classes and previous year questions, but also the 100% coverage of the syllabus of code 08, code 55 and code 17. So get in touch with Human Peritus for your preparation.